The durable powers of attorney make sure that somebody can handle your affairs if during your lifetime you're not able to do so because of some incapacity. The advance directive, healthcare directive living will, that puts into writing what your wishes are if you are at end of life. It says whether or not you want heroic measures or whether you don't want such measures to prolong the process of your dying. We're going to talk a lot more about these. I just wanted to give you a real quick explanation. Living documents. Those are the estate planning documents that protect you while you are alive. Why they're important is they make sure that you will have your voice heard even when you can't speak because of incapacity. Your wishes will be known. Your money, to the extent it can be, will be protected. And you and that trusted individual who you put into the role of being your attorney in fact under your durable powers of attorney, that they will be in control. Because if you will recall, without having living documents such as your durable powers of attorney, should you lose capacity, the state's plan steps in for you, which is a court-ordered guardianship, conservatorship, where all your affairs are publicly, your care plan is put into the court. Your financial plan is put into the court. Your guardian conservator has to get court orders to take action for everything that happens. And all of this costs money through the guardian, if they're professional, through attorney's fees, the motions that need to be filed, on and on and on. All of this can be protected against if you have your own plan and not the state's plan. Your own plan, when it comes to your living documents, is pretty simple. Have your durable powers of attorney in place. What's the power of attorney? It is a legal document that you sign that says, I grant authority to whomever to manage my financial affairs. And if, for example, my husband can't do it, then it's my daughter. And if not my daughter, then it's my son. You have successor levels of people that you appoint as trustee or as attorney in fact. They're also known as agents or POAs. Basically, it means they can act on your behalf when you can't. Your power of attorney will grant authority over your financial matters, to take care of your bank accounts, to sell property if needed, to change beneficiary designations, whatever needs to be done. They can do it because you would want them to, because if you could, you would do it yourself. And you've appointed people that you trust. Some people say, I don't want to appoint anybody right now because I want to be in charge. Well, of course, as long as you're capable of being in charge, you will be. The attorney, in fact, is your fiduciary. They can't step in and take over for you when you don't want them to, as long as you have capacity. That's where sometimes it gets more difficult because the person thinks they have capacity and they don't. They're making a lot of mistakes. There is an elder law attorney can help walk you through how to make that a successful situation. But what I will tell you is, if you are faced with the question of, should I make my power of attorney document effective immediately or later, springing on my incapacity, always I say, make it effective immediately, because you trust that person. They can't act, and you don't want to have to put them through the situation of having to get doctor statements saying that you're incapacitated. It's a really difficult situation to put somebody in. Elder law attorneys will agree, make that power of attorney effective immediately. Why do elder law attorneys agree with it? Because we deal with the situation all the time of what happens when people haven't made it effective immediately and all the problems that come up. So I just was mentioning powers of attorney for financial matters. You're going to want to have a power of attorney for healthcare matters as well. Obviously, the healthcare is to address your healthcare. If you are incapacitated and can't tell your doctors what you want, somebody needs to speak for you. There's a way the state's plan, if you don't have a healthcare power of attorney, is that there is a hierarchy of who can speak for you for healthcare. But there is no such backup statutory protection if you don't have a power of attorney for your financial matters. And I want to point out, if you're married and you think you can act on your spouse's behalf without a power of attorney, that is not correct. You might think, I can act on behalf of my spouse. We're married, we're in a community property state. Both of our names are on that bank account. Okay, so maybe both of you can handle the bank account. And if your spouse loses capacity, you can still manage the bank account. But can you sell your house? No, you can't. If your spouse loses capacity and you don't have an effective durable power of attorney that gives authority to you or somebody else to sell the house, then your incapacitated spouse will be subject to a guardianship, and you need to work with their guardian. It could be you, it could be somebody else, to sell your house. And that's not easy. It requires the court to approve it. So what I'm saying is, don't think that because you're married, you've got it covered when it comes to powers of attorney. You don't, unless you have your own plan with your own powers of attorney in place. As an elder law attorney, I will also mention that when somebody in a couple loses capacity, sometimes that's when we're going to start looking into Medicaid asset preservation strategies, a way to qualify the ill spouse for Medicaid benefits. If we don't have a good durable power of attorney for that person, it makes it much more difficult for us to implement very effective strategies. So that is another reason to not do the power of attorney yourself. Have your durable power of attorneys drafted by an estate planning and elder law attorney who does understand Medicaid. All right, who should you appoint as your attorney? In fact, somebody you trust with your money and your life. And I don't mean that facetiously. You appoint somebody who you trust, who is capable, who will effectively carry out their job, that they have the ability to do so, the time to do so, that they are well suited to do that. So you want to appoint somebody who you know will do the job when that job comes up. The other living document that I haven't mentioned much is the living will. It's also called in Washington the Advance Directive. It's called more generally Healthcare Directive. That's where you put into writing your end of life wishes. By doing that, you're going to ensure that your voice will be heard. You're going to minimize conflict with your decision maker, your healthcare agent, as to what you want. That's going to alleviate guilt and the burden of maybe what's a really tough decision, such as, removing life support. The thing about an advance directive to keep in mind is it doesn't come into play until your attending physician or two physicians have put into writing that you are at end of life, that you are in a terminal condition, permanent unconscious. And so having an advance directive in place doesn't mean that you're not going to get all of that emergency care, all of the care that you need prior to that point. It's only when the doctors with reasonable medical probability have said that you are at end of life, then does that advance directive come into play that says what your wishes are. Generally, people's wishes are that they don't want to have the dying process prolonged. However, it's up to you.